Welcome, everyone. This is Thomas Force from the Patriot Group and the Force Law Firm. I'm happy to be back with all of you again. And I want to discuss a topic that is very important, but I think is not really discussed or understood, and is a danger for not understanding it. Thus, the name of my presentation, The Dangers of Waiving Patient Balances, what every physician should know. I will tell you that my email address is here, bottom right. Feel free, if you have any questions at any time, to send me an email. That's my office telephone, or you can reach out to the association directly. They know how to get me. And I'm happy to answer any question that any of you all may have. So I just want to dig in right now and get started. So this is our agenda. This is what we're going to discuss. We're going to discuss the general concepts of what the insurance carriers refer to as fee forgiveness, waiving cost share balances that are owed by the patient. They call it fee forgiveness. We're going to discuss how Medicare and other federal plans deal with this issue, False Claims Act and the Anti-Kickback Statute. Then we're going to discuss how non-Medicare and non-federal plans, such as commercial plans, deal with fee forgiveness, in addition to the Maine state insurance law. Then we're going to discuss health plan language. We're going to discuss the interchange with the new federal No Surprises Act and analogous state law. I think it's good to understand that the federal No Surprises Act that was passed a couple of years ago, and it has a huge impact in this area. So I'm going to spend a little time discussing that. Then we're going to discuss out-of-network providers versus in-network providers. I'm assuming most of you all are in-network providers, but I will discuss out-of-network as well. We will discuss the federal government's position on waiver of patient cost share responsibility. Patient cost share responsibility, I'm talking about deductibles, co-insurances, co-pays. We're going to discuss financial hardship programs where you can actually waive patient responsibility legally, professional courtesy, prompt pay discount programs. I have a few cases as illustrations we can discuss. And then I'm going to discuss a exclusionary language in plans relating to fee forgiveness, why the insurance carriers such as Cigna have done this, and what's the ramifications. And then more importantly, I'm going to discuss, if you get an audit like this, how to defend it successfully. Just as an aside, my company is a revenue cycle company, but I'm also an attorney. And I do a lot of defense of insurance company audits representing practices. It just so happens that fee forgiveness audits in 2024 were the most common audit that I've been contacted, to provide defense for. It's a big, big business for the insurance carriers. And I mentioned Cigna because this is big, they're one of the most prevalent carriers that do this. They make hundreds of millions of dollars from this. So there's a lot of money at stake for the insurance companies. And this presentation is just to open your awareness. Just be aware and maybe take the steps that are necessary to make sure you're never in a situation where you have a fee forgiveness audit. Okay, so general concepts. Fee forgiveness. Financial hardship keeps many patients from seeking medical care because they understand that they're going to have high out-of-pocket payments, which they want to avoid. So many healthcare providers often forgive or waive co-payments, co-insurance, and deductibles to assist these patients. So I mentioned here, isn't that a good thing? What's the harm? Whose money is it anyway? Many of the doctors I speak to, they tell me, well, listen, I just want to help my patients. I'm a compassionate person. They can't afford to pay their $20 copay. So, on its face, common sense wise, you would think there's no big deal, right? What would be the problem? There's some major problems with waiving cost share like that. Many times it's the most compassionate healthcare providers are the ones that get audited because they're the ones that are trying to do right by their patients. Okay, so I mentioned whose money is it anyway, right? So the whole point of co-pays, deductibles, co-insurance is to prevent overutilization, and that's common sense. I'll give you an example of my own experience. I last year needed to see a chiropractor, and I was in network, and I had an in-network deductible that ended up being $50 per visit. So in other words, it was almost as if I was a self-pay patient. I was paying $50 for every single visit for chiropractic care. Now, because it was $50 a visit, I limited it to 2 times a week for a month straight. If I didn't have to pay that $50, maybe I would go 3 times a week or 4 times a week for 3 months. So the whole point of deductibles and coinsurance is to limit overutilization of treatment by your patients. So why is this important? So if you're waiving balances, as you will see, the insurance companies contend that the waiver of balances, such as coinsurance and deductible, is tantamount to insurance fraud. That if they're able to establish insurance fraud, they can sue you civilly. You can have penalties, monetary penalties, and even jail sentences for some of these. All right. So even if you're not dealing with the government, on the left side of the screen, commercial insurers allege fraud, common law fraud, breach of contract, and intentional interference with a contract right. They say my contractee, my patient, let's say, in most healthcare plans, the patient is required to pay their copay, coinsurance, and deductible. If you're waiving it, you're interfering with the business contract between the insurance company and the patient, and that's a tort. Intentional interference with a contract right is a tort. And lo and behold, when insurance companies sue you for this, first cause of action is intentional interference with contract rights, breach of contract or implied breach of contract, and common law fraud. Okay, so I would recommend very strongly to not waive any coinsurance or deductibles for Medicare or any government plans. I would just, as a general rule, not do it. Because if you're in an audit by the government, these federal statutes are very scary and come with criminal and civil penalties. And they also offer exorbitant compensation for whistleblowers. So if someone in your office knows you're doing this on a Medicare beneficiary and you've done it for years, and they go to the CMS, and CMS goes to the federal prosecutors, you could be facing criminal and civil penalties, and your employee or ex-employee could obtain, over $1 million of a judgment, as far as a whistleblower compensation. It's just not worth it, I say. So just real quick, again, most Medicare claims come with a 20% coinsurance. I would not waive those for any reason. I'd make that a general rule in your office. You don't want to play games with the federal government, in my opinion. So the False Claim Act is a tool for knowingly submitting a false claim. There's no specific intent to defraud, and knowing includes not only actual knowledge, but deliberate ignorance or reckless disregard for the truth. The insurance companies argue that if you're submitting a claim for $100 and you're waiving a $20 coinsurance, the charge is being overinflated. It should be $80, not $100, and that's a false claim. On the other side, the Anti-Kickback statute, it prohibits offering any remuneration to induce a person to purchase or order medical services. All right. So if you're reducing a coinsurance, that's an inducement, at least in the eyes of the government. And so you could attend, if you're waiving a coinsurance on a Medicare patient, you are technically violating the False Claim Act and the Anti-Kickback statute. Now, if it's a one-off case, you don't have a lot to worry about. But if this is a pattern, that's what the government looks for. They're looking for a pattern. And if it's a pattern over a course of several years, you could have a problem. So, and anyhow, that's how Medicare and other federal plans deal with fee forgiveness. I cite here that you have a Maine False Claims Act. I provide you the title number, and I gave you the definition of a fraudulent insurance act, which also means a false representation of a material fact. So if you're waiving deductibles and coinsurance on commercial plans, you could be violating the Maine False Claim Act as well. And I cite the Maine Criminal Code also for fraud. And that False Claims Act law in Maine contains a whistleblower protection provision similar to the anti-kickback law we just discussed. And it's a state law. Many of the state laws, including Maine, mimic the federal laws. So that's why these commercial payers are, fee forgiveness audits are big business for them. They make millions of dollars from this kind of stuff. Okay, we talked a little bit about this. I just want to make the point here that you don't have to just worry about fee forgiveness, waiving deductibles, coinsurance, copays for Medicare and other government federal programs. Commercial plans also have, as we just discussed, Maine State False Claims Act law mimics the federal law and has whistleblower protection. So this applies not just to federal plans, but to commercial plans as well. That's the point. So, like I mentioned before, many of the health plans have provisions in it that basically require your patients. Remember, even if you're out of network, your patients have contracts with the various insurance companies, the Aetnas, Cignas, the Blue Crosses. And in the contract, there'll be language that basically requires them to pay their coinsurance and deductible, even goes so far as to pay the difference between charge and payment if you're out of network. So that's why the insurance company argues that if you're waiving patient cost share responsibility, you're contributing to breaching the contract between the member and the insurance company. That's intentional interference with cautious intentional interference with a business contract. That's the allegation they always raise. So later on, we're going to talk about Cigna adding a provision that basically facilitates their audit mechanism. It's really remarkable. So keep in mind that the reason why we're talking about this, it's not just about possible civil and criminal penalties. The insurance companies have latched on to fee forgiveness, and it's become $100 million business for them. And I'll give you some examples of some cases that I'm handling right now for some providers that are really outrageous. And we'll talk about that later on. Okay. I just wanted to mention the Federal No Surprises Act and the Maine prohibition on balanced billing, which I cite here as well. If you're an out-of-network provider, again, I think many of you are in-network, but if you're an out-of-network provider and you're performing services at an in-network facility, be it an ambulatory surgery center or a hospital, then the Federal No Surprises Act would apply. And in that scenario, the general rule is you're going to bill the patient the in-network cost share only. Again, that only applies to out-of-network providers performing services at an in-network facility, such as a hospital. In such instance, you're going to bill the patient the in-network cost share, not the out-of-network cost share. And Maine Title 22 Health and Welfare Law, Subtitle 2 Health, Part 4, Hospitals and Medical Care has a similar provision. Most states mimic federal law when it comes to no surprises. The point of that law is basically making sure that patients are not penalized when an out-of-network provider goes to an in-network facility, whereas the patient believes that all of the services are in-network, but some are not. So that's what that provision is about. There are some exceptions, and the patient, in some instances, not emergency services, but in some instances, the patient can waive the protections under the Act. The waiver has to be on a form that is prescribed by HHS. I have a copy of the form. Feel free to reach out to me if you think the Federal No Surprises Act may apply to you. Pop me an email and I can talk to you offline, provide you the requisite forms that you need in order to protect your practice. In addition, I'm assuming that my slides will be available to everyone in the association, but if not, email me and I'm happy to provide them to you. So that's the Federal No Surprises Act. I can tell you that my surgical clients, this is having a big impact in their world because of a provision that requires the insurance company and the providers to negotiate in good faith for 30 days. And if they can't reach an agreement, then you can go to IDR, which is an arbitration in this independent dispute resolution. And my clients have been doing very, very well in IDR. I've been going to IDR arbitration and winning a lot of money for them. And those are mostly for surgical clients. But I just raise it. You really should know about, if you're in the healthcare space, you should know what the Federal No Surprises Act is all about. And again, I'm happy to provide any information offline that you need if you think this may apply to you. The waiver doesn't apply for emergency services and for ancillary service providers. Those are providers you would not expect, that a patient would expect that they would be in network, such as an anesthesiologist or an assistant surgeon. You can't waive the protections under the Act for providers where a patient would assume that they're in network, such as an anesthesiologist or a assistant surgeon. Anyhow, this is not what I wanted to talk about today, but I think it's important that we raise the Federal No Surprises Act. So let's talk about out-of-network versus in-network. My query is, does it matter if the provider is out-of-network or in-network with the insurer? Okay. For fee forgiveness purposes, not really. The only difference is out-of-network providers, their patients have a higher cost share. Deductibles are usually, in excess of $500. Co-insurance is typically 50%. Out-of-pocket max could be as high as $10,000. But if you're in network or out of network, you could still be fee forgiving and still be subject to a fee forgiveness audit. Most of my clients that I defend audits and fee forgiveness are out of network, but I have one right now that's in network as well. So I think that this is a concern that should be a concern for both in and out of network providers, is the point. Okay, so this is, again, this is the insurance company speaking. If the practice is an example, if the practice is in network, there's a $50 copayment for each office visit. The practitioner feels bad for the patient when the patient complains about the copay. I have a lot of bills. I'm going through a divorce. I was sick. Practitioner feels not waiving the copayment may result in complaints by the patient, which could affect his or her practice reputation on social media platforms. This is actually a question one of my clients called and asked me about. Says, now this patient's kind of a troublemaker. She may go on social media and badmouth me. So the practitioner decides to waive the copayment for each visit or reduces it to $25 per visit. This is fee forgiveness. Even if he reduces it to 25, that's a $25 per visit waiver of copayment. Over the course of 3 months, that could add up to, $500,000. The insurance companies deem that to be fraud. This is a situation that most practitioners would feel to be not a big deal, trying to help a patient. Practitioners and certainly the federal government, CMS, they would view this as insurance fraud. Okay, so what are the views of the federal government? We talked a little bit. The Medicare plans, the TRICARE plans, other government programs. Well, the Office of the Inspector General states that Medicare's cost share requirements, quote, is an important control on overutilization of items and services, right? We talked about that. If beneficiaries are required to pay a portion of their care, i.e., copayments, they will be better healthcare consumers selecting items or services because they are medically needed, again, to avoid overutilization. The routine waiver of medical now this is from the Office of the Inspector General for CMS. The routine waiver of Medicare coinsurance and deductibles can violate the federal anti-kickback statute, as we've discussed, if one purpose of the waiver is to generate business payable by a federal healthcare program. Just like I said, don't waive cost share responsibility of a patient for a government program. Bad idea. A separate statutory provision prohibits offering inducements, including cost share waivers, to a Medicare or Medicaid beneficiary that the offerer knows or should know are likely to influence the beneficiary selection of a particular provider, practitioner. So, in other words, it's not just the anti-kickback; it's also the False Claim Act. There are two notable exceptions to this, where financial hardship of if you can establish a legitimate financial hardship of a patient, you can legitimately waive a patient cost share responsibility, so long as the waiver is not offered as part of any advertisement or solicitation. If you're going to offer free whatever, don't advertise that. That violates not just what I'm talking about. There are also advertisement laws, prohibitions in the licensing and education department laws that you have to be concerned with. So, financial responsibility may be a legitimate way to waive a cost share of a patient, as long as the waiver is not part of an advertisement or solicitation, and as long as the party offering the waiver does not routinely waive coinsurance and deductible amounts, and the party waives the coinsurance deductible amount after determining in good faith that the individual is in financial need or reasonable collection efforts have failed. And I put here documentation. Now, so here's the problem, okay? I can't tell you how many clients I've had that have waived cost share after I've been involved in an audit. And, if you do it once or twice or occasionally, it's not that big a deal as long as you document. I suggest, and we'll talk about, you should have a written policy. It should be objective. But, I've had providers that waive almost every cost share, and they're not like in a ghetto area either. And they can't really justify the waiver. It's like they're saying they put in their chart financial hardship, and they just waive every cost share. That's not going to cut it with Medicare. It's not going to cut it with an audit from a commercial payer. So the question is, you want to make sure you're not routinely waiving coinsurance and deductibles. You want to make sure there's a good faith financial need and reasonable collection. Now, when I say reasonable collection efforts have failed, at a certain point, you can write off a patient balance as long as you can show that you've made a reasonable attempt to collect. Maybe you sent 3 statements and a couple of phone calls. Documentation is key. Most providers don't understand how important it is to document these type of things until they get audited. So I say here, what constitutes a good faith determination of financial need? Well, again, we look to the federal government. According to the Office of Inspector General, the financial need may vary depending on the individual patient's circumstances and several factors. Now, these factors should be in your financial hardship policy. So some of the factors, the local cost of living. Is it high or low in your demographics where the patients come from? Patient's income, assets, expenses, a patient's family size, the scope and extent of the patient's current medical and past medical bills. In other words, document a real, legitimate financial hardship, and you need to have objective criteria. That's the next thing. OIG says use financial need guidelines that are based on objective criteria. So I had a client once that said everyone that made over $200,000 gets a 85% financial discount. That's not objective criteria. That's made up stuff, and it gets you in trouble. And it's very important that your financial hardship applies uniformly in all cases. You cannot discriminate. So where it works for you and where it doesn't work for you. If you're going to have a financial hardship policy, then make sure it's posted on your website, posted in your office, and make it available to everyone. I can tell you that most of my clients, I tell them not to have financial hardship policies unless they're in a very depressed area. Because even when you have a good policy and you waive based on a financial hardship policy, the insurance carriers still think that it's per se fee forgiveness. So if you're gonna do financial hardship policy and use that as a waiver of cost share, make sure it's not a routine waiver of most of your patients. It should be a one-off. It should not be a regular thing that happens in your office. Make sure that you have a really objective plan. You can go online, for example, and look at what hospitals use. You just put hospital charity care or financial hardship policy. Their policies are pretty good. They're pretty stringent. The policy should be difficult to satisfy, to satisfy financial hardship. You could also use a sliding scale based on income, but documentation is the key. I also point out that the OIG recognizes that providers can have a good deal of flexibility in making these decisions, but they caution against inflated income guidelines, like I just discussed, for patients not in genuine financial need. The other thing I recommend is you can't have a financial hardship document approved with documentation and maybe tax records today and not have the patient reapply the following year or maybe 6 months from now. People's income and financial stability change. So you need to have the patients, longstanding patients, reapply for financial hardship at least once a year, if not every 6 months. Financial hardship. I spent a lot of time on this because I get a lot of questions about financial hardship. A lot of providers want to waive balances because it's good for their practice. It's good for their social media presence. Makes patients happy. And a $20 copay is not going to kill them. They can afford to waive it. But like, I'm just warning you that these financial policies have to be done professionally. They need to be very objective. You need to have backup. Someone can't just say, I lost my job. Are you on unemployment? Provide unemployment documentation. Someone can't say that I'm not making more than $20,000 a year. Have them provide their tax returns, federal tax incomes records. If they're on food stamps, let them provide documentation. The more documentation you have, the better. So the OIG also warns that, quote, the financial status of a patient may change over time, and the provider should recheck a patient's eligibility at least in reasonable intervals sufficient to ensure that the patient remains in financial need. That's what I just discussed. should be at least once a year, if not every 6 months. The OAG also recommends that providers obtain supporting documents such as tax records, proof of unemployment, support the financial decisions with backup. Document, document, document. You'll appreciate that if you ever get audited. So you should have someone in your office responsible for financial hardship if you're going to do it. Create a really good policy. Make sure that there's plenty of documentation and it's well documented, and keep those records for at least the statutory period that you would have to keep your patient's medical records. That's my opinion. Professional courtesy. Everybody gives professional courtesy to, colleagues, employees, etc., right? So it's not a bad idea to have a professional courtesy policy. Waiving charges for, like I said, I'm a lawyer as well. I have employees. I give them free legal advice. I'm sure that if your office manager needed medical care, you wouldn't charge her co-payment or deductible. So this is not necessarily illegal, but I caution you that at least according to the government, HHS said that these practices risk running afoul of anti-kickback statutes, false claim act, and state fraud laws. So I haven't seen a lot of enforcement in this area. I would say keep the professional courtesy policies narrow. So in other words, if you want to make it colleagues in your specialty at the hospital or your employees, it can't be your employee's uncle's cousin. I think you know what I mean by that. All right. Professional courtesy. It could be a legitimate reason to discount patient financial cost share. We've talked about financial hardship policies, professional courtesy policies. Let's move on. Prompt pay discount policies. I don't like these. There's only a couple cases that I found where courts have said that prompt pay policies could be offered as an inducement and to receive other services. So in other words, if you pay quickly, your cost share is not $50, it's $40. I can just tell you, I don't like these at all. I recommend don't using them. If anyone wants to use a prompt pay discount plan policy, I would say, let a compliance expert like myself look at it, compare it to your statute in your state, and that's all I have to say about it. There are cases out there in certain jurisdictions where courts have said, yeah, prompt pay discounts policies, if they're clear on their face, they're objective, and the prompt payments are quick. The understanding is that if you're paying the provider quickly, they can avoid the cost of collections. So the savings in the collection area is really the discount you're allowed to offer, if that makes sense. Again, not crazy about these plans. I recommend to my clients not to use them. So if there's any other questions about them, just send me an email. So I cited a couple cases here. I literally have dozens and dozens of cases. You could, this is a case where in-network providers, your contract may allow your plan to deny the entire payment if the fee is improperly forgiven. So 2 or 3 years ago, I started seeing provisions in health plans where exclusions are put in that says if you waive a cost share for any reason, it could be financial hardship or any reason, they can deny the entire claim. And that's what this case is about. So the provider sues for $5.6 million. Cigna defended on the ground that, apparently the provider was in a fee forgiveness audit. Provider said, usually what happens in these audits, the insurance company, and Cigna is the biggest player in the fee forgiveness world. insurance company will ask, will send questionnaires to your patients, and it will ask them if the provider waived or reduced their deductibles or co-insurance, and if they feel during their investigation there's fee forgiveness, they'll stop paying your claims, in this case to the tune of 5.6 million, and then they'll ask for all of their money back based on this exclusion. And that's what this case is about. All right. Provider says you owe me a lot of money. So let me tell you about a case that I'm handling now. I have a provider in Manhattan that has high charges. He bills for cost share, but the insurance company, Cigna, believes that that his practice is waiving substantial amounts of cost share. The reality is that's not really true. The cost share is not being billed to patients primarily because the insurance company hasn't paid the claims yet. You know, when the insurance company pays the claim, then you bill the deductible or co-insurance listed on the EOB, right? Well, in this case, Cigna decided, after doing an investigation, sending questionnaires to patients. I would highly recommend that you tell your patients that anything they get from an insurance company, including a questionnaire, they should bring to the office. Ask them not to fill out questionnaires or documents for the insurance companies. Bring it into our revenue staff to look at before, so in this case, they said, they'll send out 10 questionnaires when we're dealing with thousands of cases. If they get one that says, yeah, my provider said I don't have to pay the cost share, boom, you're in a fee forgiveness audit. So what they did was they went back in time, in my case, because there's an exclusion in their plan that says that if the patient is not liable, well, I have the actual exclusion for you later on in the presentation. But if the your patient is not liable for the charge, or if you're in network for the deductible co-insurance, they don't have to pay. So they paid over $3 million to this provider over the course of the last several years. They want all that money back, and they stopped paying claims. And I'm fighting that battle right now, and I think I'm winning the battle, actually. But I have a bunch of cases like that, not just with Cigna. So you should be aware that the insurance companies have a lot of lawyers, they have a lot of resources and money, capital, and they've set up their plans so that it makes it easier for them to do these type of fee forgiveness audits. And we'll talk more about that as we proceed. So we got about 23 minutes left. I think we have plenty of time. All right. Here's a case of tortious interference. In this case, the insurance company alleged it was an out-of-network provider. Out-of-network provider said, hey, I have no obligation to do anything as far as billing balance bills or cost share letters. Insurance company said, we have a contract. This is Aetna. We have a contract with our member. Our member agreed in their contract that they would pay for their deductible and co-insurances. You have told our member that they don't have to pay their deductible and co-insurance. Therefore, your conduct has intentionally caused our member to breach their contract because they're required to pay their deductible and co-insurance. So that tort is called tortious interference with a business contract. And that's what this case is about. In this case, Cigna sued this is an out-of-network provider, for $4 million, alleging that it engaged in unlawful fee-forgiving practices that excuse Cigna's obligation to pay for services provided. So in other words, this is the game plan. And this is why it's big bucks. If we find out that you're fee forgiving or even reducing patient cost share responsibility, we're going to ask for all of our money back, and we're not going to pay any claims. And we're going to allege fraud. Okay? So Cigna asserted claims for recoupment of those overpayments, fraudulent and negligent misrepresentation, and legal theories of promissory estoppel, fraud, and violation of the Illinois Consumer Fraud Act. The court found enough evidence of improper fee forgiveness to allow the claims to go to trial. This case was eventually settled, I believe. Okay, so now let's talk about Cigna's not the only one that has an exclusion like this. but let's talk about it. These exclusions are put in to make it easier, in this case for Cigna, to file, to conduct a fee forgiveness audit where they can recover. I believe these companies have recovered hundreds of millions of dollars on fee forgiveness audits against out-of-network and in-network providers. So this exclusion in their plan, now remember, there's a provision in the plan we discussed already where the member is required to pay their cost share responsibility. This is in addition. This is an exclusion. An exclusion says, you see, second paragraph, when Cigna administers or underwrites a plan, we don't cover charges not billed to you or that you aren't required to pay. So this provider client of mine started getting exclusions of claims that cited this exclusion, saying you weren't billed, you're not being held responsible for your cost share responsibility, so we don't have to pay it. And by the way, all the claims we did pay, you owe us the money. Okay? So the net effect of this exclusion is it facilitates or makes easier Cigna's ability to conduct provider audits successfully against in and out of network providers based on fee forgiveness. So you need to be aware of this. This is a topic, like I said in the beginning of the presentation, I'm not sure that any of you spend a lot of time thinking about, but you should. You should be very wary and concerned about this. And I've seen an uptick in these type of audits in 2024 as opposed to 23 and 22. I'm personally handling about 7 of these. And when you get one of these, it's a shocker and it's really distressing to the provider. It also has a major impact on the patients because how do you prove that the patients are responsible for their cost share responsibility? Well, you bill the patients. You cite the financial agreement you have with the patient. So all of these actions by Cigna or the other insurers against the providers ultimately has a major impact on the patients. And basically it freaks out your patients. They'll never want to come to your practice again. They'll blame you. From a social media standpoint, it'll trash your practice, and it could potentially lose you a lot of money in the audit. And it also, you won't be able to see, in this case, Cigna patients anymore. And if you do, you're not going to get paid. So the worst thing that can happen in a provider audit is what I mentioned in number 3 below, right side of the slide. Yeah, they're going to stop paying you claims. They want all their money back, but they may potentially report you to regulators for fraud to put additional pressure on you. I had that happen in Arizona, and I think that's really a terrible thing there's no proof of fraud when they conduct these audits, even if they do an investigation. And I had a client that was reported to the Office of Professional Discipline based on fee forgiveness. And it's terrible. These special investigation units, their goal is to scare you and to make money. And I believe they get compensated based on how much money they bring in to their company. And these audits are legal. They're definitely legal. And I wish that our legislators would take up some of these issues because I'm seeing an uptick in this, and it's really hurting. Ultimately, it hurts the consumer, the patient. I have a handout with an audit letter from United Healthcare that I redacted out all the personal information. That's a handout. I hope you have it. I wanted you all to see what a real audit letter looks like. In this case, it was a letter from United Healthcare Empire Plan, which administers the state health benefits in the state of New York. And it's kind of a scary letter. And all of the things that I've been talking about anti-kickback and fraud, are all contained in that letter. And the position of the insurance company is outlined very clearly. that they believe that waiving or reducing of patient cost share responsibility, such as deductibles and coinsurance, is tantamount to insurance fraud, that the reason why the deductibles and coinsurance exist is to prevent overutilization, and by waiving balances and then billing full charges to an insurance company, it's tantamount to insurance fraud because the charges are being overstated. So take a look at that handout. It's a kind of a scary letter one of my clients received. The good news is I resolved this matter very, very successfully for the client. And I even they were out of network, and I got them a really good in-network agreement as a result of the audit. The audit ended up being a good thing for them. That's not always the case. So let's talk about, if you get an audit, you might say, you know, the insurance law, let's say in New York, insurance companies can't go back more than 24 months, okay, from the date of EOB. I'm not sure what it is in Maine. I think it might be 12 months, but in any event, um, you know, the insurance companies can avoid state statute of limitations if the plan is employer sponsored and governed by federal law, which is ERISA. That they usually try to circumvent the state limitation for refunds and overpayments. All right. I can tell you that I can defeat those arguments. So what I want to talk about now is, how do you defend an audit for fee forgiveness? First of all, you should recognize it by the first line of defense is educating your patients. All right. Anything they receive, questionnaires, calls from investigators, they should report to you. So educate your patients. All right. If you get a letter from an audit department or a special investigation unit that asks for not just medical records, but they want patient statements and ledgers showing how much each patient is paid, that's a tip off that you're in a fee forgiveness audit. Okay. So let's talk about how to defend this. First and foremost, like I said, is identify that one is happening. Number two, an audit needs to be responded to in writing, and any refund demand has to be appealed. Keep in mind that refund demands are retroactive denials. They're saying, we paid this, but we shouldn't have because we didn't know you were fee forgiving. So that's like any other denial. You have to appeal it. So what I do is I usually file a written objection and appeal to audit. And certainly if there's a demand for a refund, that certainly warrants a written appeal. So the first thing that I would do is I address the statute of limitations argument. Many times the auditor, when they're looking for money or they're requesting documents, they'll go beyond the statutory limitation. Under insurance law, every state has a limitation under fraud, not under fraud, sorry, excuse me, under refunds and overpayments for insurance or medical claims. And there's usually a limitation 12 months from the date of payment. An insurance company cannot request a refund more than 12 months from the date of payment. All right. If there are any requests that for documents or information beyond that 12 months, I object to it. I say the statute of limitation for the state of Maine is 12 months. I'm not sure it's 12 months. I'd have to look it up, but let's say it's 12 months. Most of them are 12 months. New York is 24 months. It's horrible. Texas is only 180 days. So I say you can't go beyond the 12 months. And even for ERISA plans, self-funded plans, most of the case law says if ERISA has no statute of limitation, like states do, but most of the courts say you use the most analogous state law with respect to the statute of limitation. So, they can't go back, 3 years. So I try to cut down the audit from the get-go. I don't let them get documents beyond 12 months. I limit any demand for damages by the 12 months or 18 months, whatever the state statute says. What the insurance company says is, under those laws, they're usually in your prompt payment law in your insurance statute. The insurance companies take the position that, well, even if that law did apply, every one of those laws has an exception. You can't ask for a refund more than 12 months, except where there's evidence of insurance fraud. Then you can go back forever. So the insurance companies say, well, even if that law does apply, which we disagree with, there's insurance fraud going on here. There's fee forgiving, insurance fraud, overstating of charges. And therefore that statute doesn't apply. That's their argument. I disagree with it. I think that it's very, very hard to prove insurance fraud. That's really hard. You have to, under the law, you have to specifically allege the fraud. It's difficult to prove. So I always argue, I say, give me a break. Waiving a $50 copay is not tantamount to fraud, especially when it was waived based on a financial hardship policy. So anyhow, again, the insurance companies take the position ERISA has no statute of limitations. And like I said, not entirely true. So that's my first level of defense. I try to limit the scope of the audit and the damages. The second thing is, well, let me hit the third thing first. You should have a strong financial agreement with the patient. If you have a strong financial agreement and you get audited, that's very, very helpful. Your financial agreement should state that the patient is responsible for ordinary coinsurance, co-payments, deductibles. If you're out of network, they're responsible for the balance bill, which is the difference between charge and payment. I always throw in there non-covered services to the extent that they don't violate the in-network agreement and No Surprises Act or state no surprise laws. So having that agreement is important because one of the best defenses that you have to an audit is to start sending balance bill or cost share letters to patients. All right. So if you haven't done it, we send it. And in most states, like in Maine, sorry, I misspelled Maine, MAINE, 0.2C. In Maine, you can go after a patient for a medical debt 6 years after the last activity on the debt. That's a long time. So if you have, let's say the audit is 3 years out from the date of the EOB, and you didn't send any statements, but you have a strong financial agreement, and you didn't tell patients they're not responsible, you just didn't bill them, you can bill them. The insurance company will say, oh, well, you're billing them because of the audit. And I would respond, so what? In Maine, I have 6 years. So I'm well within my statutory right. How are they going to argue that the patient is not legally responsible if you're sending a cost share letter and you're making a reasonable good faith effort to collect? So you have to make a good faith effort to collect. Insurance companies realize you cannot collect all of the cost share. You're not required to sue your patient or put them in collections. You should send them a cost share statement. You should send them at least one. AMA recommends 3. You should document those statements were sent, maybe have copies of them, document your efforts to collect. But at a certain point, you don't have to sue your patient. You can write it off. But as long as you document your good faith and reasonable efforts to collect, you're good to go. Documentation is key. So we talked about statute of limitation, sending cost share letters, even if they're late. Maine is 6 years. Having a strong financial agreement with the patient, and sending appeals on audit findings. So if they send you audit findings saying that our investigation has determined that you're fee forgiving, I would send copies of my cost share letters and my financial agreement and say, how could you argue that we didn't make a reasonable attempt to collect when we have a financial agreement that holds our patients legally responsible for the debt? We sent cost share letters, and so we're appealing this audit finding as incorrect, and any retroactive denials in writing. And if you're not paying us, you need to start paying us. And like I said, if it's a big case, like 7 figures, retain someone like me. I would recommend. You want someone that understands revenue cycle and understands specifically fee forgiveness. Okay. My presentation is over. Like I said, this is my email address. I'm very, very happy to respond to anyone that emails me for any reason. I'm happy to help anyone in the association because they've been very good to me. And I hope this has been very, very helpful to you. And any of the forms that I discussed, if you would like copies of them, I don't have a financial hardship and a prompt pay policy because those are more case specific. But I can help you with a sample professional courtesy policy, for example. Happy to provide it. And take a look at the handouts that I provided. I also provided a questionnaire, a sample questionnaire that Cigna sends to your patients, so you can get a feel for what the patients are asking. Educate your patients to make sure they alert you if they receive anything from carriers. And I thank you so much for your time.